Some people may find parts of this judgment upsetting. I would like to know your thoughts on this judgment. Do you think he got what he deserves? Or do you think he should have got longer? Introduction. Lord Justice William Davis. On the 7th of September 2021, the offender, Adam Fleming, pleaded guilty to a single offense of causing grievous bodily harm with intent. His plea was tendered on the day that the case was listed for trial before His Honour Judge James, sitting in the Crown Court at Canterbury. On the 7th of December 2021, the offender appeared before the same judge for sentence. The judge imposed an extended determinate sentence of 18 years with a custodial term of 14 years and an extended licence period of 4 years. The Solicitor General seeks leave pursuant to Section 36 of the Criminal Justice Act 1988 to refer the sentence to this court as unduly lenient. The facts of the case are as follows. From about 2016, the offender, born in March 1994, was in a relationship with a lady named Kelly Webber. They lived together in a flat in Ramsgate. Ms. Webber, born in 1972, was considerably older than the offender. She was an extremely vulnerable individual. She suffered from borderline personality disorder. She had learning difficulties. She was subject to more than one physical disability. She had suffered abuse as a child. Because of her vulnerability, she had been allocated a social worker. The relationship was volatile. Neighbors regularly heard screaming and shouting coming from their flat. Ms. Webber often would be seen with bruises and black eyes. Her social worker had tried to safeguard Ms. Webber by providing her with places of safety away from the offender. On the 7th of January 2021, the social worker visited Ms. Webber at her flat. The offender was present. Ms. Webber had significant facial bruising. When asked how she had sustained her injuries, Ms. Webber said that the offender was not responsible, but she gave no positive explanation of their cause. The offender was playing on an electronic tablet device. He apparently had no interest in Ms. Webber's welfare. The social worker told Ms. Webber that he would arrange an appointment with her GP. On the 9th of January 2021, Ms. Webber sent the social worker a voice message. In the background, the offender could be heard saying, "I am going to do this all night," following which Ms. Webber cried out in pain. On the 11th of January 2021, the social worker went to the flat in Ramsgate in order to collect Ms. Webber and take her to the GP appointment. He received no answer even when he knocked on the door repeatedly. He shouted through the letterbox, but there was no response. After about 10 minutes, he left. He went back to his car. As he was driving away, he received a telephone call from the offender who said, "Something is wrong with Kel, she's had a fit, she's making funny noises." The social worker told the offender to call an ambulance and then return to the flat. There he found Ms. Webber lying on a sofa with obvious and very serious injuries. The offender was speaking on the telephone to emergency services but was showing no sense of urgency or any particular concern for Ms. Webber. The social worker took over the call and made it clear that there was a real emergency. Ms. Webber was taken to hospital. She had the following fresh injuries: brain damage with internal bleeding, multiple facial fractures including the nasal bones and the left cheekbone, substantial facial bruising, corneal dislocation causing blindness in the left eye coupled with other traumatic injury to that eye, extensive bruising to the chest and abdomen, fractures of 4 ribs, 3 on the left and 1 on the right. There were old fractures of 4 ribs, 2 transverse processes of the lower lumbar spine and the right cheek. Ms. Webber was treated initially in intensive care. After 10 days she was transferred to the high dependency unit where she underwent extensive physiotherapy and occupational therapy. She was transferred to 2 different hospitals, first in February and then in March 2021, before being transferred to a neurorehabilitation unit in July 2021. She made very slow progress over the course of 2021. As at the 26th of May 2021, she had significant communication and behavioral deficits, which meant that she was wholly dependent on others to meet her needs. Her cognition was severely affected. She needed full nursing care to maintain continence, nutrition, and hygiene. By the 19th of September 2021 she had made some progress. She then was able to feed herself with assistance. Her behavioral problems had improved and she was able to communicate with others to a limited degree. She remained doubly incontinent. The expectation in the longer term is that Ms. Weber will be able to live in sheltered accommodation. However, she will not be able to look after herself and will need close supervision. She will not be able to walk independently. The offender was arrested and interviewed. He provided a prepared statement in which he said that he was not responsible for any injury sustained by Ms. Weber. He claimed that he had been in the toilet when he heard a thud. He went into the living room and found Ms. Weber on the floor. He managed to put her onto the sofa. He did not know what caused the injury, though he thought that she might have had some kind of fit. She already had a bruise on her face resulting from a fall she had a few days earlier. Otherwise he made no comment when asked questions by the police. The injuries to Ms. Weber's face and body were caused by repeated blunt trauma, i.e. blows delivered with considerable force. Medical expert opinion was not able to determine the specific cause of particular injuries, save that the facial fractures were consistent with blows from a fist or a foot and the brain injury was indicative of an accelerated fall backwards due to a blow or blows to the front of the face. The material considered by the judge. The offender's record of previous convictions included convictions for assault in 2011 and 2012. Otherwise, his appearances in court between 2013 and 2020 related to minor offenses of dishonesty and drunk and disorderly. The offender declined to be interviewed for the purposes of a pre-sentence report. He attended a video conference with a probation officer. But as soon as the probation officer asked him about the offense, to which by now he had pleaded guilty, the offender stood up, shouted abuse and left the video conference room. A report nonetheless was prepared to deal with the issue of dangerousness, the probation officer being able to speak with social workers and others who had dealt with Ms. Weber and the offender in the months and years prior to January 2021. The clear conclusion of the report was that the offender presented a very high risk of serious harm to Ms. Weber and any other partner he might have in the future. For obvious reasons, no VPS was taken from Ms. Weber. There was a statement dated the 9th of September 2021 from Ms. Weber's daughter. Amongst other things she said this: "The hospital has told me that their main goal is to get my mum to use a Zimmer frame to walk from one side of the room to the other. It breaks my heart that this is their main goal, as I do not know if I will ever see my mum back to her old self. I believe that my mum will be in a care home for the rest of my life. My mum's emotions are all over the show. She has improved in that she has stopped scratching herself or pulling her hair as much, but she still seems very sad. I can see in my mum's eyes that she is frustrated and fed up that she can't move and get up. I have seen her cry and gets annoyed when she tries to do this. Since being in hospital my mum hasn't mentioned Adam once. It used to be the case that my mum would never stop talking about Adam. I cannot be sure if this is because my mum doesn't remember him, or if she is so scared of him that she has blocked him out. All I want is to see my mum happy. I want to be able to go out and spend time together, and it destroys me knowing that this might never happen again." There was no psychiatric evidence relating to the offender. It was submitted to the judge by counsel in the course of mitigation that the offender had twice been admitted to a mental hospital during 2020. On each occasion this had been a brief admission. Counsel said that the diagnosis had been emotionally unstable personality disorder. Counsel also referred to the fact that the offender had been brought up in care and that he had some history of learning difficulties. Sentencing. The judge began his sentencing remarks by a review of the material relevant to the risk of serious harm posed by the offender to others in the future. He concluded that there was more than sufficient to justify a finding that the offender presented such a risk and that an extended determinate sentence was required. The judge described the injuries suffered by Ms. Weber as catastrophic and life-altering. By reference to the revised Sentencing Council guideline effective from July 2021, he assessed the offence as falling into Category 1A. There was high culpability because Ms. Weber was obviously vulnerable and the assault was prolonged. Harm was in Category 1 because all of the relevant factors were present. The judge said that the fact that the assault took place in a domestic context and in Ms. Weber's own home increased the seriousness of the offence, as did the fact that the assault was the culmination of a prolonged course of violent, controlling and coercive conduct in relation to Ms. Weber. Taking into account all of those matters, the judge considered that the appropriate starting point for the custodial term before the effect of any mitigating factors and the appropriate credit for plea was 16 years. This was at the top of the sentencing range in the guideline for a Category 1A offence. The judge reduced the custodial term to 14 years, A, because the offender had not served a substantial term of custody before and had called for assistance once he had caused the injuries, and B, to give credit of 10% for the late plea. As we have noted already, the extended license period was 4 years. Submissions. On behalf of the Solicitor General, it is submitted that the judge's assessment of the proper custodial term before consideration of mitigation and credit for plea was inadequate in 2 respects. First, it gave insufficient weight to the truly exceptional level of harm caused to the victim. 3 factors are identified in the guideline as showing the highest level of harm. They are: 1. Particularly grave or life-threatening injury caused. 2. Injury results in physical or psychological harm resulting in lifelong dependency on third-party care or medical treatment. 3. Offense results in a permanent, irreversible injury or psychological condition which has a substantial and long-term effect on the victim's ability to carry out their normal day-to-day activities or on their ability to work. The presence of any one of those factors should lead to a finding of Category 1 harm. In this case, all 3 factors were present. It is argued that this meant that, subject to discount for plea, a sentence outside the category range of 10 to 16 years should have been imposed for this reason alone. Reference is made to the concept of extreme impact as referred to in the guideline. Second, there then should have been a further uplift to reflect the aggravating factors. The offence occurred in a domestic context. The injuries were caused after a prolonged course of violent, controlling and coercive conduct. The offender had failed to adjust his behavior despite what amounted to warnings from Ms. Weber's social worker. The Solicitor General does not argue that this is a case in which it was contrary to the interests of justice to follow the Sentencing Council guideline. See Section 59 of the Sentencing Act 2020. We have considered the provisions of Section 60 of the 2020 Act. It may be said that, in a case where no category sufficiently resembles the circumstances with which the court has to deal, the sentence properly will fall outside the range identified in the guideline. The proposition would be that the facts of this case were not reflected even by the highest category within the guideline. We shall return to these issues later. On behalf of the offender, Mr. Wells, who appeared in the court below, invites us to consider the following: the possibility of some further recovery on the part of Ms. Weber so that she may not be fully dependent on third-party care, the offender's limited criminal history which could amount to mitigation within the guideline. The fact that the judge was fully aware of the domestic context when he referred to the history of coercive and controlling conduct, the offender's own vulnerability and difficulties. Taking those matters into account, the sentence imposed was not unduly lenient. Mr. Wells accepts that the evidence established a history of violence and coercive behavior on the part of the offender. With that in mind, some judges might have taken a starting point outside the category range, but it was not unduly lenient to avoid that course. We are satisfied that the combination and nature of the culpability factors and the extreme nature of the harm suffered by Ms. Weber required the judge to move to the top of the category range before any consideration of factors increasing seriousness. It would not have been reasonable to do otherwise. That approach would not involve any departure from the guideline. Having reached that point, the judge was obliged to give proper weight to the factors increasing seriousness and any mitigating factors. In reality, there were no mitigating factors of any substance. The fact that the offender had not previously been sent to custody other than for a very short time had no impact when the instant offense was as serious as this one. The offender may have called for assistance, but in reality this was only at the behest of the social worker. Any problems and difficulties which may have afflicted the offender could not be said to have had any relevance to his behavior towards Ms. Weber. The factor's increasing seriousness was substantial. Given the nature of the relationship between the offender and Ms. Weber, she was effectively defenseless in her own home. The violation of trust was acute. This was not a case of a sudden outburst of temper in an otherwise good relationship. As accepted on the offender's behalf, there was a long history of violence and coercive behavior on his part. He continued to behave in that way despite the intervention of social workers trying to act in the best interests of Ms. Weber. In his submissions to us, Mr. Wells said that maybe that the offender thought that he could behave like he did. That clearly was the case. It adds substantially to the overall seriousness of the case. Having considered the factor's increasing seriousness, we find that the only proper sentence before credit for plea was significantly outside the category range identified in the guideline. On that basis, the sentence imposed by the judge in this case was outside the range of sentences which reasonably could be considered appropriate. We reach this conclusion simply by applying the guideline. Given our conclusion following a conventional application of the guideline, necessary it is not for us to consider the extent to which Section 60 permits the departure from a guideline. In respect of offence-specific guidelines, Section 60, 2, imposes a duty on a court to impose on an offender a sentence within the offence range. In the case of the guideline with which we are concerned, the offence range is 2 to 16 years. Nothing in the later subsections of Section 60 undermines that duty. There is nothing in Section 60 which assists our consideration of this case. We give leave to the Solicitor General to make a reference to this court under the provisions of Section 36 of the Criminal Justice Act 1988. We find that the sentence imposed on the offender was unduly lenient for the reasons we have set out. Prior to consideration of the factor's increasing seriousness, a sentence at the top of the category range was the only appropriate sentence. Taking those factors into account and giving due weight to the appalling consequences which will affect Ms. Weber for the rest of her life, we conclude that the appropriate custodial term before credit for plea, but allowing for such little mitigation as was available, was 19 years 6 months. Credit for plea, as correctly determined by the judge, will be restricted to 10%. We quash the sentence imposed by the judge, namely an extended determinate sentence of 18 years with a custodial term of 14 years and an extended license period of 4 years. We substitute an extended determinate sentence of 21 years 6 months with a custodial term of 17 years 6 months and an extended license period of 4 years. The effect of the substituted sentence is that the offender will serve 2/3 of the custodial term of 17 years 6 months before he is eligible for release. Whether he will be released at that point will be a matter for the parole board to decide, who will only release him if they consider it safe to do so. Whenever he is released, he will remain on license for any remaining part of the custodial term and for a further thereafter. 4 years.